Good morning. Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the matter of Seepersad against the Commissioner of Prisons of Trinidad and Tobago. The appeal concerns the remand of two children within the criminal justice system of Trinidad and Tobago. In particular, it concerns the questions whether the place and circumstances of their detention constituted detention without due process in breach of Section 4A of the Constitution, or a breach of the right to protection of law under Section 4B of the Constitution. I'm Lord Lloyd Jones, and today I'm sitting with Lord Hamblin.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Sir Bernard McCloskey.
Good morning.
The appellants are represented by Richard Clayton, Queen's Counsel, Anand Ramlogan, Queen's Counsel, Kate O'Reilly and Rowan Pennington Benton. The respondents are represented by Howard Stevens, Queen's Counsel, and Daniel Goldblatt. Mr. Clayton.
If it please your lordships, can I just confirm that the case of Ray's found its way to you yesterday?
Yes, it did. Thank you.
Thank you very much. Can I just introduce the case in this way? This appeal concerns two children, aged then 16 and 12, who were charged on the 24th of January 2014 with two adults with murder, which is in Trinidad an unbailable offence under the Bail Act. On the 29th of January 2014, Sasha and Brian, the two appellants, were remanded in custody for the first time. Sasha to a women's prison at Goldgrave and Ruka, and Brian to St. Michael's, a youth training centre, which is an industrial school for young male offenders between 16 and 18. The orders made in respect of remanding them to those places became unlawful on the 18th of May 2015 because of breaches to Section 54(1) and Sections 61 and subsection 5 of the Children Act 2012, because on that date, the 18th of May, the Children Act came into force. Well, those sections came into force. The Court of Appeal upheld the High Court in finding that the detention was unlawful in breach of the Children Act. Section 60, subsection 1, prohibits Sasha from being detained in an adult prison, where she was held from the 29th of July 2015 to the 7th of December 2015. Brian, on the other hand, was remanded to a youth training centre from the 29th of July 2015 to the 14th of April 2016. Section 54(1) required Sasha and Brian...
Mr. Clayton, could I just ask you, what were the circumstances in which Brian ceased to be held on the 14th of April 2016?
Yeah, I think, my lord, the position is this. I may need to come back to you on it. I think he continued in St. Michael's, but as I understand it, the statutory regime in Trinidad changed to reflect the fact that they were struggling to adhere to the Children Act. But can I return to that, because that's my understanding, but I may have misunderstood that.
Thank you.
What I was saying was, I was going to say Section 54(1) required that Sasha and Brian be remanded to a community residence, which is a defined and licensed form of detention for children. And Section 65 prohibited Sasha from associating with adults when in prison. The Court of Appeal proceeded on the basis that it was for the courts to resolve a friction between the Bail Act and the children legislation, or more specifically, the two sections I've referred to. Our case is that the friction which the courts wrestled with resulted from the failure of the executive to give effect to the children legislation. In reality, the conflict between the Act, between the Bail Act and the Children Act, resulted from the executive failure to do what Parliament required it to do, and it's on that basis that we submit there are breaches of Section 4A and 4B. What I hope to do now is just briefly summarize, I hope, the respective cases that are advanced before my lords and summarize them. There is no dispute between the parties, which we confirmed with Mr. Stevens on the 10th of March, that executive action or inaction can in principle breach section 4A or 4B. In our submission, the difference between the parties is a dispute concerning the proper scope of these two rights. The right under 4A is a right not to be deprived of liberty without due process of law, and under 4B, a right to equal protection. In relation to those rights, we rely on the following. First, sections 54 and 60 of the Children's Act clearly impose mandatory duties. Second, that section 54 and 60 aim to secure international obligations arising from the United Nations Charter of the Rights of the Child, particularly Article 37, which is designed to protect a vulnerable class of individuals, namely children prosecuted who are detained in custody. Thirdly, once legislation is implemented, as it was in this case by a presidential proclamation, the obligation on the executive is to give effect to it by virtue, effectively, of the principle of parliamentary sovereignty. And that simply did not happen here. Fourthly, the court will give great weight to the parliamentary intention and its legislative purpose. And in our respectful submission, the legislative purpose of sections 54 and 60 are both important and plain. Our complaint is that the executive chose to implement the acts, implement section 54 and 60, but failed to take the further and necessary steps to comply with those statutory mandatory duties. It simply failed to make them up, having decided to make them operational, failed to give them effect. In our submission, the executive failure breaches what Lord Bingham described in the famous St. David Williams lecture, that's the core principle of the rule of law, that all persons and authorities within the state, whether public or private, should be bound by, to be underlined, and entitled to the benefits of laws publicly and prospectively promulgated and publicly administered. In our respectful submission, this simply did not happen. Accordingly, we submit that the failure of the executive to give effect to the legislation in force, which it chose to put in force, breached the principle of parliamentary sovereignty, certainly in relation to the executive, and the principle of separation of powers, because the executive trespassed into the power of the legislation to enact legislation, and that, with respect, is plainly contrary to the rule of law, which I shall demonstrate shortly, is the governing principle that Lord Millett identified in Thomas and Baptiste. The respondents, by comparison, assert the following, that the appellant's complaint is simply about the place they were detained and does not involve any question of fundamental rights. And they further assert that the appellants can only demonstrate the breach of a constitutional right if they can also show that this involved cruel and unusual punishment. I should say that there's no authority for that proposition, and it is with respect wrong. Our answer to the respondent's characterization of our case is this. On the evidence, the executive decided to implement sections 54 and 60 by presidential proclamation, but it failed to take any further and necessary steps to give effect to the legislation it chose to implement. The problem faced by the courts in resolving the friction between two legislative regimes, the Bail Act and the Children Act, arose as a direct consequence of the failure of the executive to give effect to the legislation as the rule of law requires it to do. In our submission, the respondent's suggestion that this case involves no breach of fundamental rights is circular and ignores the fact that compliance with the rule of law, namely parliamentary sovereignty in relation to the executive and the separation of powers, are breaches of foundational constitutional principles. And it's been those breaches of foundational constitutional principles, which is why this is a constitutional case. As to the right of equal protection, to summarize our case about that, the point that we emphasize there is the scope of equal protection is very broad. In fact, it's actually undefined. And it certainly includes omission of the state to comply with the rule of law. That was one of the things which the Mayor Leader's case says, which was approved by the board. I'll come to that in due course. The respondents, however, contend that equal protection simply requires access to the court. With respect, we submit that that simply is wrong. It's much broader in scope than that. And we make two different points. First, that it was an arbitrary decision of the executives to fail to give effect to sections 54 and section 60. And secondly, that access to the court was rendered ineffective or inefficacious because it was effectively impossible for the Court of Appeal to resolve a problem which was of the executive's making. Can I make that point good, if I may, by looking at the evidence which in our submission is central to our case? In our submission, it's the evidence about the steps taken by the executive to implement the legislation, which is central. And for that purpose, can I ask you to turn to, it's 1839 of the electric bundle. And may I say at this juncture that I'm afraid I lack the computer's skills, so I'm working from paper. So if that becomes a problem, I apologize in advance. Now, if you go
to
to 1839,
thank you.
If you turn the page, it's an affidavit of Juliana Johan Budrum, and you see that at 1840. And if you see from paragraph 2 that she's the permanent secretary to the Ministry of People and Social Development. Can I invite my lords to read the witness statement, which you may not have had the opportunity of reading before, and then make some quick submissions about where it takes us?
Yes.
It's the status that matters, and that's what they're getting.
No one's ever read this.
Didn't know what substituted with blinds means. I'm trying to see it.
Okay. It's not good.
Yes, Mr. Clerk. Thank you.
Thank you, my lord. I want to just make a couple of points, if I may. My lords will have seen that Miss Boudram is a senior civil servant. She was charged with by the ministry with explaining the background to this. What I particularly want to draw your attention to is at 1842 4 Roman 3, where she says a decision on the 14th of May was taken to advise the president to fix the 18th of May as the day which certain legislation came into force. That's undisputed as a matter of fact. It's important to appreciate two separate things. This was the date where the government chose to implement Section 54 and 60. And there are a number of things which her witness statement does not address. It does not explain a decision not to implement, and there were no steps taken before the 18th of May to implement Parliament's purpose in enacting Section 54. The witness statement fails to address, and this is important in the context of rights under the UN Convention, about how the rights of the children were balanced against public interest, simply silent on that question. There's no explanation as to why the executive made a conscious decision with respect not to implement Section 54 or 60. And we say it must be conscious because it's simply unexplained. And what is striking in our submission, and I think I can take this point quite shortly because my lords will have just read the rest of the witness statements. In our submission, the steps taken after the 18th of May 2018 were the steps that were required to be taken beforehand. This case is about a Parliament enacting legislation, the executive purporting to implement it and doing nothing of the kind. And I want to make an additional point, which is this, is the witness statement stops at a certain point in time, but the problem for the court remains. It is still stuck trying to make sense of what to do with the fact that the Children Act is in force and cannot be given effect to. It's noteworthy that although this affidavit from Ms. Boudram was filed on the 15th of October 2015, it was never subsequently updated. My lords may also think it relevant, a point which Lord Bingham made in the Tweed Parade case, that there's no attempt to exhibit any exhibits at all, no exhibits. The documents may have provided some assistance to my lords, as they would to any court, to explain what has happened here. They're simply silent. And that, with respect, is, in our submission, unsatisfactory. And the central point we want to make is this, is that in our respectful submission, this witness statement demonstrates that the executive failed to take any further unnecessary steps to give effect to sections 54.1 or the two provisions of section 61 and 5. They simply did nothing. This appears to be a very unusual position because normally steps are taken before legislation comes into effect, whether by proclamation or otherwise. In this case, that didn't happen. And that is the central thrust of our submission to my lords. Can I next move to the statutory framework, please? And here I may slow down a little because as I blunder through the paper. Can I first turn up the Constitution, which my lords will find, now I've made a mistake. My lords will find at 2013, the Constitution of the Republic of Trinidad and Tobago. Do my lords have that?
Yes.
Turning to the preamble, and I do this because of the way in which Lord Sumption refers to it in the Ferguson case. If you could go to subparagraph D, you'll see that the Constitution is founded amongst other things, on the rule of law. And that becomes important because I'm going to submit that is the organizing principle for both of the rights which are in dispute in this case, which is why it's a debate about the scope of the right. And in our submission, Trinidad, perhaps unsurprisingly, plainly takes the rule of law principle as a key element in its constitution. The next provision I wanted to take you to is at 2015, if you would turn there. I wanted to take you to the section 2, the supreme law section. This constitution is the supreme law of Trinidad and Tobago, and any other law that is inconsistent with the constitution is void to the extent of the inconsistency. So this case, this constitutional, like most in the Caribbean, gives paramount status to the constitution. If my lords could turn through to pages 216. If my lords have that, section 4A is a right of the individual not to be deprived of his liberty except by due process of law, and the right of the individual to equality before the law and the protection of law. And then an issue which we don't pursue before my lords in section 5, if you could turn to that at 2017, B, to impose or authorize the imposition of cruel and unusual treatment or punishment. Those, I think, are the only constitutional provisions I need take my lords to. The next point I want to come to is the Rays case. I hope you've put that at the back of your bundle. I'm afraid that's what I've done.
You have to bear with us for a moment, I think. Yes, we have it as a separate document.
Yes, I'm so sorry about that. I'm sorry it didn't occur to me sooner to.
Not at all.
Sorry, the inevitable disaster happens. My binder is full. What I'm going to do is ask one of my juniors to do some emergency work, but I'm going to take you to Rays at the same time. So if you just bear with me, I don't think it matters for present purposes. The facts of Rays, no, don't worry. The facts of Rays don't, I'm going to go straight to the relevant passage, if I may, which is on the internal page 246, if you have that.
We have it as a separate document of 24 pages.
Yeah, oh, does it not have page numbers on it? It should have been we sent you the appeal court's copy, appeal cases.
Page
12.
I'm so sorry, but you have it in the appeal.
We have the report in 2002, 2 appeal cases, 235.
Yes, thank you very much. Well, I was going to ask you to turn to 246, please.
Thank you.
Could you give me the paragraph number, please, Mr. Clayton?
Yes, it's 26.
Thank you.
Which I think we told you before. I'm going to take this again at speed, but going through it, if an enacted law is said to be incompatible with the right to be protected, first court's duty is interpretation. That's not relevant here. After that, just above C, it must interpret the Constitution to decide whether the enacted law is incompatible. Decided cases around the world have given valuable guidance on the proper approach to the courts of constitutional interpretation, and you see reference to quite a lot of cases from United States, Canada, elsewhere. And then picking it up just above E, as is the case of any other instrument, the court must begin its task of constitutional interpretation by carefully considering the language used in the Constitution. It does not treat the language of the Constitution as if it were found in a will or a deed or a charter party. A generous and purposive interpretation is to be given to the constitutional provisions protecting human rights. The court has no license to read in its own predilections or moral values, but, and this is important too, it is required to consider the substance of the fundamental right at issue and ensure contemporary protection of the right in the light of evolving standards of decency that mark the progress of a maturing society. My lords, that I think is still the best current and clearest exposition of what constitutional interpretation for our purposes is. Importantly, for our purposes, it draws on what's possibly the first case, a Canadian case of Edwards in 1930, when Lord Sankey referred to constitutions as being a living tree capable of growth. That's the territory we're in. We're dealing with substance, we're dealing with purpose, and we're dealing with reflecting current standards. And that may be of some importance when we're dealing with legislation which is, in our submission, designed to give effect to the rights created by UN Charter of Rights of Children. If I could move on from the question of constitutional interpretation to the Bail Act and the Three Children Acts, the Child Suite, which they're sometimes called. I don't need to take you to very much of it, but what I would do is make a couple of general points before going to the provisions of the Children Act themselves. The legislation some of it has been enacted some long time ago, and it appears to be, some of it has been amended. It's quite difficult. I was trying to, at some stage, produce a table of what was in force and what was not, but I'm afraid Trinidad defeated me, not for the first time. The problem is that that you can see that sometimes it's done by proclamation, sometimes it's done, as with the Children Authority Act, in the body of the Act, like Section 2 itself. But what I would like to do is to look at the Children Act, please, which you will find in the first bundle, which is the one I think I wrecked. No, I didn't. Which is, sorry.
1921, I think.
That's right. Thank you so much. I'm sorry, I'm just less dexterous than I once was. If I could ask you to go to page 1962. If you have that. Can I assume you do?
We do.
Yes.
Thank you. Section 54(1), a court on remanding or committing for trial a child who is not released on bail shall order the child to be placed in the custody of a community residence named in the order for the period for which he is remanded or until he is brought for the court. In our respectful submission, Section 54 is a pretty straightforward piece of interpretation. We draw attention to the word shall, and we draw attention to the fact that a community residence is defined rigorously, and the bottom line is no effect was given to it. If I could then ask you to turn to page, page 1971. If you have that. Section 60, subsection 1 says a court shall not order a child to be detained in an adult prison. Again, in our respectful submission, it's pretty obvious what that means. It means exactly what it says. Shall not means must not. Sections Section 3 and subsections 3 and 4 are not in effect but don't matter. But I just tell you that because it's one of the constant difficulties, identify what's in force, what is not. But Section 5 in our submission is important. Where a child is detained in any facility, he shall not be allowed to not be allowed to associate with adult prisoners except with the express permission of the court in respect of the adult prisoner named in such order. Now, in our submission, one has to read the whole of that provision together. The first thing is that, again, the word says shall not, and it means what it says. This is an absolute prohibition. Unsurprising, you might think, that a child should not be associating with adults, which obviously is likely to occur in an adult prison. But with respect, section 60, subsection 5 is rather more rigorous than that, because in order to justify an association, the court has a role, the court has to give express permission, and it has to name the adult prisoner. And with respect, that never happened, and it certainly doesn't justify what happened to Sasha. I think at this stage, that's the only legislation I need to take you to. I'm going to come back to a point in a minute. The next point I want to make is that for our purposes, the legislation in question here, sections 54 and 60, and actually a bit of other stuff too, came into effect by proclamation, an act of the executive presidential proclamation. It's conventional in our submission to phase implementation of legislation, which is actually what's happened here. My lords will see that, as I demonstrated, I think with section 60, some bits were given effect to, some were not. In our submission, this ability to phase implementation gives the executive an opportunity to make considered choices as to what provisions it wants to implement and as what decisions it doesn't want to implement. That's the purpose of the exercise. The straightforward point we make in our submission is this is a fundamental principle of constitutional law, is that if the executive decides for whatever reason to implement legislation, it must give effect to it. It's not a complicated case, but it's an important principle. The next point I want to make, and I'll take this at some speed, is that in our submission, it's pretty clear that the purpose of section 54 and 60 was to give effect to the United Nations Convention on the Rights of the Child, specifically Article 37, which you'll find at 2841. Sorry, that's not right. Yes, 2841. Do my lords have that? Sorry, I'm struggling with the binders.
Yes.
That's right. Correct. Yeah.
Thank you. Well, it's really C, it's Article 37C I want to draw attention to. Every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner which takes into account the needs of persons of his or her age. That's the particularly pertinent passage. It's, with respect, is not a, well, I've been asked to, separate. Oh, I'm so sorry. In particular, every child deprived of liberty shall be separated from adults unless it is considered in the children's best interest not to do so. That's also important. And with respect, it isn't surprising that one would detain vulnerable children in an institution which does not permit association with adult prisoners. And in our submission, and there are other reasons for saying this, if one looks at other elements of the Act, the whole, the three acts together, the suite of children, are designed to reflect and attach importance to the UN Convention rights. And we therefore say that the approach the courts really ought to take is that they have to look at the purpose of the legislation when assessing the significance of its breach. The next point I want to make is another example, and this is really just to correct an error which appears in our case, which is that in our case, we refer to Section 3 Big A of the Children Authority Act, which is a very unusual provision which gives direct effect to the UN Convention. I'm afraid we've subsequently confirmed it doesn't impinge on this case because it came into force in 2017. But it doesn't impinge in this case for another reason, which I'm about to explain. Now, to step back to make this point, if one looks so far as you can at the structure of this legislation, what the structure intended, if all of it was in place, which it isn't, but I'll come back to that, was that community residences were supposed to be licensed by the Children Authority. That is quite important. That's what was supposed to ultimately happen. Now, the government made a deliberate decision not to enable it made a deliberate decision that the Children Authority, as in 2015, had no role in licensing community residences, and that's important because of the decision, the nature of the Children Authority and the roles it was supposed to perform. Can I take you to the record now, which is a first instance judgment of Mr. Justice Cochrane when he draws attention to this. It's at page 448 of the record, which is yes. If you have that, I'll pick it up at paragraph 37, please. Paragraph 37. Community residents are defined in the Community Residence Act as a children's home or rehabilitation centre. They fall under the jurisdiction and regulation of the Children Authority established under the Children Authority Act. The Children Authority Act provides for a regime of licensure for such residences. However, that section does not yet come into operation. Under that system, it would be illegal for anyone to operate a community residence without a license. There are currently no licensed community residences in Trinidad and Tobago at which minors could be placed, as a system of licensure has not yet been proclaimed. This does not affect the fact that residences can be considered community residences as long as it fits the description of such a residence contemplated by the Act. The Children Authority has recognized the existence of 48 community residences in this jurisdiction, which are being assessed and monitored, no doubt until the system of licensure is complained. There are 2 rehabilitation centres and 46 children homes. The authority recognised serious deficiencies in their state of readiness to be licensed, and my lords will have in mind the various passages cited in the judgments about the assessments made by the Children Authority and indeed by others. The short point I want to make really goes to the broad point I make at the outset, which is that the government has the power to decide and make informed choices about when to implement legislation. And that's what this particular observation by Mr. Justice Cochrane demonstrates. They made the choice not to give the Children Authority the licensing duties to license community residents. What the Parliament and what the executive did not do was give the authority for Section 54 and Section 66 to be inoperative. And just to complete my submissions on this point, if my lords look at, I should go backwards. Can we turn up the children community?
Before you move on, Mr. Clayton, I'm not sure I understand that point. You say they made the choice.
I've taken it to. Can I take you to the legislation to show you why I say what I've just said?
I'm not sure I understand what you have just said.
Oh, I'm so sorry. All right. Well,
They made the choice. I'm sure it's my fault. They made the choice not to give the Children Authority the power to license
yes.
for the purposes of section 54 and 56 to be
No, no,
inoperative.
no. For the license, just they were under the overall schema of the Act. The Children Authority is supposed to license residential, forgive me, community residences.
Yes.
That's the taking the Act, assuming all of it had been implemented. In fact, what had happened here was the government, or the executive, it is in fact, chose not to introduce the Children Authority's licensing power at this stage. And the broader point I'm seeking to make from that is this one, which is no one quarrels, subject to a point I'll come to it in a minute, no one quarrels with the power of the executive to decide how and when to implement legislation. That is a matter of conscious choice for it to decide. But that is a completely different scenario from when the government decides to implement legislation, as it did sections 54 and 60, but doesn't provide the relevant facilities. That's the distinction I'm making. It may be a clumsy one, for which I apologize.
Thank you.
And if I could just make good the statutory basis for that, we need to turn up the Children, Community Residence and Foster Care Act. Just give me a moment. That's going to be in volume 1 of these.
It begins at page 2026, Mr. Clayton.
Thank you very much. And it's what we want to look at is section 3 and section 5. Section 3 is at 2032, and section 5 is turning the page. Section 3, the only part, section 3.1 is the power or the requirement to have a license by the Children Authority. That is not in force, as in 2015. Section 2, which states that no child should be cared for, provided with accommodation, unless it's been issued, but again by the Children Authority, again is not in force as of 2015. So the government has made a conscious decision to avoid the Children Authority having that licensing role. If you then look at subsection 3 of section 3, it says in this part, license means the person to whom a residential license is granted under section 5. So section 5 therefore defines the scope of the licensing obligation as it existed before sections 3.1 and 3.2 were put into effect. And if you then turn to section 5, I'll just let you read it, and it speaks for itself. It's essentially procedural in nature. And then where's the proclamation?
Are you saying that subsection 3.3 was in force?
3.3 was, but not 3.1 and 3.2.
I see.
Yes. And then what I want
Mr. Clayton, I think you may have given us the later statutes. We have the 2000 statutes, but we would be looking, I think, for the statutes which were on the books in 2015.
No, my lord, we're giving you the right statutes. Can I? The problem is that Trinidad, unlike us, don't refer to legislation by the year. And that's because if you look at some of them, like the Children Authority Act, it's a bit of a movable feast, what we're talking about. But I can assure my lord that these are the correct provisions in force. We've taken quite a lot of time to ensure if we could achieve that, which has not always been straightforward. But what I wanted to take you to, could I just ask you to keep your finger in section 3 of the Fostering Act, which is at 2032, and then go through to the proclamation for this act, which is to be found at 2023. That's tab, what was that? 6. If you have that, you'll see that where it refers to the sections of this act which are in force, it's section 1, section 2, section 3.3, section 4, section 5. So you can see that no attempt has been made to, well, this isn't a criticism, but they haven't enacted or proclaimed section 3.1 and 3.2, which is why the learned judge, Mr. Justice Cockeram, drew attention to it. But it is significant for other reasons. But as I say, what in our submission, this somewhat technical point, some might say, demonstrates, is that there is a important distinction between the choice that government has as to when to implement legislation and the fact it has no choice, once implemented, to give effect to it. That is this distinction which we seek to draw to my lords. There is one slight wrinkle on that, which is the fire brigade case, which I'll briefly summarize and remind my lords of. It doesn't really bear on this case. It actually is discussed by Mr. Justice Cockeram, but it doesn't bear on the case. Just to remind my lords of the facts of the FBU case and then the principle. In the FBU case, what happened in that case was that the Criminal Injuries Compensation Board had been established for a long time under the royal prerogative. The government in 1988 wanted to replace the prerogative scheme with legislation. In 1993, it decided to replace the existing non-statutory scheme with another non-statutory scheme in circumstances where the 1988 legislation had never been brought into being. And the House of Lords decided in that case that there was a continuing obligation on the Secretary of State to consider whether to bring the statutory scheme into force. He could not lawfully bind himself not to exercise the discretion conferred on him, and the prerogative scheme he wanted to implement did precisely that. But subject to that one wrinkle on the ability, well, perhaps not subject to but subject to that important qualification on the powers of the executive to decide when to implement legislation, that is the extent to it. And here, as I've said, and this is a point which here we're not concerned with that point here. We're concerned with a different point which Boudram's evidence goes to, which is legislation is in force and no explanation is given as to why it hasn't been given effect to. Can I now turn? Sorry. In our submission, this is the rule of law principle, and this is the nub of our case, prohibits the executive from failing to implement Section 54 by issuing a proclamation and then refusing to give effect to it. It can't do both. If it decides to proclaim it, it's got to give effect to it. If it doesn't want to give effect to it, then it shouldn't proclaim it. But the executive has no power to trespass into the parliamentary role by allowing Parliament to make Parliament's entitled to make the legislation, but deciding to implement and then just ignoring it. And in our submission, the evidence of Ms. Boudram does precisely that. Can I next make our specific submissions on the constitutional rights we're concerned with here? And I want to start, if I may, by looking at the judgment of the Court of Appeal, which is, I want to begin at 1224, which is, it's 3. If I could ask you to turn to 1224. The judgment itself begins at 1191, but I needn't burden my lords with that. I want to begin, as I say, at 1224. And I want to begin with this issue. My lords will see above paragraph 85, were the orders for detention unlawful, which was the conclusion that the trial judge made. And just to swiftly invite your lordships to notice it, my lords will notice that paragraph 86, the authority carried out an assessment of conditions at St. Michael's. Only 6 of 52 requirements were met. More said about that. Then paragraph 88, Miss Gemmon deposed that the authority contacted this is 88, all community residents. None were found to have the minimum requirements for rehabilitation centre. 89, the authority concluded there was no suitable community residents to accommodate Brian. Turning the page to 1226, the authority carried out a similar exercise with respect to Sasha, fourth line down in paragraph 90, compliance with 15 of 52 requirements only. Based on its 91, based on its investigation, the authority expressed the view no suitable community residents for the accommodation of Sasha. Then to invite you to look to 1227, if you would please, paragraph 95. I want to come back to this a bit because it's wholly irrelevant, but the state tried to get comfort from this. There was no challenge to the suggestion that community residents were, so the government was bona fide as were at issue. I'll return to that later. If you could go to 1228 now, paragraph 98. This is where the judge deals with the dilemma that the courts were faced with. And before I take you to, can I make a general, but in our submission, important point? We make no criticism of the court's difficulties in giving effect to what appears to be a friction between two different constitutional regimes. They simply were trying to do the best they could in a difficult situation. But the responsibility for that, like the court's difficulty, lay with the executive. And that's what gives this case its constitutional flavor. Had the executive done what it was required to do, which was to give effect to legislation it had promulgated, then the problem would never have arisen. It's a direct consequence of a significant failure by the executive to do that which it was required to do. Now, this, with respect, doesn't appear to have been appreciated much. If we take it up from 98, there's a point made about the chief magistrate. He asked Brian to be placed in the custody of the children authority, while the authority is mandated to provide, this is by section 51A, to provide care of the Authority Act to care and protection and rehabilitation, not empowered by the Children Act to establish community residences for the purpose of detaining child defenders. In our view, the appropriate order would be for the state to provide suitable community residences to accommodate Brian within a reasonable time. The same view was expressed in respect of Sasha. And this is where, in our submission, the case took on a slightly puzzling quality. 99, Mr. Mendez submitted that the chief magistrate was placed in a position where it was impossible to comply with section 54, 1 and 60. He had no choice. Then paragraph 100, the proposition is an attractive one which accords with common sense. Where a court is faced with a situation where it is not possible to comply with two conflicting statutory mandates, it must do the best it can in the circumstances. Paragraph 100. The inescapable fact, though, is that in making the orders for remand, she, the chief magistrate, was plainly contravening the express provisions of sections 54(1) and 60. Although the court is not unmindful or unsympathetic to her position, contravention of these provisions plainly renders her orders unlawful. The reason I take your attention to that is, with respect, the submission that the courts were placed in an impossible position missed the point completely. The point in this case is not about the court's problems, who did the best they could, but that the executive had not provided them with the facilities in line with the act which the executive chose to implement. And that's why this case is about the failure of the executive. Yes? Sorry.
Did your client have a claim for false imprisonment in this case?
Well, there is a claim for, it's put as a constitutional claim. There is a difficulty about, perhaps I should deal with it now. In some instances, the tort of false imprisonment and deprivation, contrary to section 4A, run side by side. And there are cases which say that. I mean, I'll explain the general point in a minute, but if I could just deal with the cases themselves. My lords have them in the bundle. And the cases which say that are Lord Clark and Rama Singh, which, to give you the reference, is 2523 at paragraph 8, Roman 1, which is at 2527. And then a very well-known passage from Lord Diplock in Maharaj number 2. Maharaj number 2, my lords may recall, is the case about a barrister who was sent to prison, someone who some of my lords may have seen in the board, who was sent to prison and was never given the opportunity, an answer to have the charges against him, and that was unfair. Anyway, in that circumstance, and it's at 2427, paragraphs 397, that's D to G. 397, I'm afraid, is the internal pagination reference. I haven't.
Mr. Clayton, could you give the page, the paragraph reference again, please, or the page reference?
To Maharaj.
It's 2427, and the
yes,
page.
This I've given you. It's at D to G, which I think is the internal page reference 397.
Thank you.
But this case is slightly more complicated, and because I do acknowledge that the court here was faced with a rather difficult problem, because it had the mandatory requirements on the one hand of the Children Act, and it also had the mandatory requirements of the Bail Act and the obligation not to remand murder offense suspects in custody. So I'm not saying in this case necessarily it's a false imprisonment case, because I don't need to go as far as that, and I'm simply going to put to one side, because this is the constitutional claim, that debate, which in our submission is not entirely straightforward. Our complaint here is that the constitutional claim is based on the facts of this case, is the court was caught between two conflicting regimes, statutory regimes, which arose as a direct consequence of executive inaction in the face of having proclaimed the act being enforced. That's the way we put it before my lords.
So there haven't been any proceedings in respect of false imprisonment?
The only proceedings there have been, my lord, are the ones which are before my lords. So the answer, strictly speaking, is not, because I think it was treated as one and the same thing. I don't propose to trespass on old ground, if I may put it that way. But in our submission, where we end up is this: that there is a conflict. The courts clearly found that a problem to deal with. No criticism of them for that. But that was a consequence of the executive. That's how we put it. Can I then subject, unless there's anything else for the moment? Thank you. Can I next go through the judgment, and if you could turn to page 1230, there is an echo of the point my Lord Legate made before in paragraph 103, the criticism that the argument advanced by the appellant was syllogistic, because essentially it was to the effect you can see it is. But I want to move on from that, if I may. And what I want to draw attention to is this, is that I want to move on to our submissions, if I may, that the approach taken by the Court of Appeal to the deprivation of liberty without due process of law is, with respect, much too narrow, because the question is not one of due process. The question is the rule of law. And can I make good that submission, if I may, by going to Thomas and Baptiste?
Surely you can't say, Mr. Clayton, that if the question is not one of due process, there's a breach of the entitlement to due process. I mean, that's just contradicting yourself. Nor can you rewrite it.
Well, what I can do, my lord, is show my lord the authority which indicates why I make the submission I do. I accept the language as due process, but the question is, how does Lord Millett deal with that? Can someone give me the reference to that, Thomas and Baptiste? But my lord, I can't rewrite it. Can I say, and I don't be the first person to say this, I think, that that the language of Section 4 is not entirely straightforward, but I do rely on previous Privy Council authorities which wrestle with that.
Well, isn't this case more, though, about, since you put it on the basis of failure to implement the law, isn't it about protection of the law, not about the process that was followed in this case?
Well, my lord, that may be my lord's. Can I ask you to defer that issue until I take you to this authority, and then you'll see why I put it the way I do. This is Thomas and Baptiste. Can I ask you just first to read the head note in case it's...
Yes. The page reference, please.
Is 2583.
Thank you.
It's 2603. Just read it. It's quite good. When you're ready, my lords, I wanted to do, if I could ask to go to 2603. And it's a discussion of due process, which I particularly want to focus on, if I may. Do my lords have 2603?
Yes.
Thank you. Due process, picking it up just above F. The due process clause in the Constitution of Trinidad and Tobago can be traced back to the confirmation of the Magna Carta by Edward III in 1354, wherein the expression due process of law replaced the law of the land in Chapter 9 of the original version. Coke regarded the two expressions as synonymous. They protected the subject from absolute monarchy and the exercise of arbitrary executive power. This interpretation may have been appropriate in the absence of either a written constitution or a doctrine of separation of powers, and at the time when the sovereign legislature was in the habit of passing acts of attainers. But such expressions mean different things in different ages. The words due process of law were introduced into a New York statute in 1787 for the purpose of protecting the individual from being deprived of life, liberty, or property by an act of the legislature alone. Madison had the same object in 1791 when he drafted what became the Fifth Amendment to the Constitution of the United States. The due process clauses in the Fifth and 14th Amendment underpin the doctrine of the separation of powers in the United States and serve as a cornerstone of the constitutional protection afforded to its citizens. Transplanted to the Constitution of Trinidad and Tobago, the due process clause excludes legislative as well as executive, draw attention to the words executive, interference with the judicial process. The clause plainly does more than this. It deliberately employs different language from that employed in the corresponding provisions of the Universal Declaration of Human Rights and the European Convention on Human Rights. They speak merely of the sentence of a court of competent jurisdiction. The due process clause requires the process to be judicial, but it also requires it to be due. In their lordship's view, due process of law is a compendious expression in which the law does not refer to any particular law and is not a synonym for common law or statute. Rather, it invokes the concept of the rule of law itself and the universally accepted standards of justice observed by civilized nations which observe the rule of law. The clause thus gives constitutional protection to the concept of procedural fairness, and they draw attention to a decision of Mr. Justice Holmes. And then I just invite you to just read to F, and then I'll make some submissions. My lords?
Yes.
My lords, in our submission, a number of different things flow from the passages I just read. The first to note is that in our submission, Lord Millett states that the fundamental principle engaged is the rule of law, and then picking up the issue of procedural fairness on the paragraph below, that is simply an example of the overarching principle. Yes? My lord, second.
That's not how I read it, Mr. Clayton. I read Lord Millett as saying that law in that expression refers to the rule of law. It isn't just the law of the land in the sense of the common law or the proclaimed law. It's the rule of law itself that is meant by law, but there is the process part as well to be taken into account. And therefore, what it's all about is procedural fairness, but not in a sense of following the procedures introduced by the legislature or the common law necessarily, but by following procedures which are of fundamental importance, accepted standards for civilized nations.
Well, my lords, I understand the point my lord makes, but I do rely on this sentence. In their lordship's view, the due process of law is a compendium in which law does not refer to any particular law. I accept it then says it refers to the rule of law itself. Where I part company with my lord, is that that there has to be a breach of fairness in order to demonstrate that it would come within the scope of the right. I should say that I'm going to cover some of the same ground in relation to the equal protection clause anyway, so I'm not going to preempt those submissions at this stage. But I take on board my lord's point. What I would, however, say is that much of it depends on how you look at it. Because what we have in Thomas and Baptiste is the executive imposing restrictions on the ability of those subject to the death sentence of making applications to international human rights bodies. And the complaint was that effectively those instructions were given after the date of the applications made by the two relevant prisoners, and that they couldn't be retrospective, that they couldn't be treated without breaching this principle. But I do accept this certainly, that the submission I make about the rule of law is dependent upon how one reads the passage which my lord and I have just debated its scope. I accept that.
Well, there is, for example, a huge body of jurisprudence in the United States about the expression due process of law.
Yes.
And as far as I've been able to ascertain on a quick reminder of it, if you leave aside questions of substantive due process, which and all that jurisprudence on that,
Yes.
in New York and so forth, but it's all otherwise about procedure and procedural fairness.
I understand that, my lord, and let me put it this way. I can't improve upon the exposition given by Lord Millett. I'm not sure it's open to me. I make the submission that I do. I also make the submission, and this is said at several of the authorities, that equal protection and due process of law normally end up in the same place and cover the same ground. I will demonstrate that even on the narrower view of my lord's view, that in fact it's been breached for reasons I'll explain when I deal with equal protection, because in our submission, the case...
Yeah, to be fair to you, you keep saying equal protection, Mr. Clayton, but it's actually not equal protection in this case, is it? There's equality, which is one limb, and you're under protection of the law.
Well, my lord, this is a debate which the question, sometimes the board regards it as the word equal applies to both, so it's equal protection of law. Sometimes it's dealt with in the singular. It all depends on where whether equal covers the second, whether and is to be read conjunctively.
Okay.
That's the point.
Mr. Clayton, can you help me on this? I don't at the moment understand why you say that what happened in this case infringed the principle of procedural fairness.
Well, because what I will be saying is, in effect, the answer to this case is, from the respondents, that that access to the court was sufficient to deal with any procedural requirements. That's as I understand their case. If that is their case, in our submission, it fails for a number of reasons. But one certainly is that's too narrow a view of the equal protection clause, but leave that to one side. The reason we say it fails is because, as the Mayor Leader's case makes clear, access to the court has to be effective or efficacious. And here, the reality of the position is that the appellants derived no practical remedy from access to the court. That's the problem.
I see. That's how you put it. My Lord, Lord Hamblin has a question for you.
Certainly.
Just going back to the question of whether due process goes beyond procedural fairness, can you, is there any case you can show us which shows it going beyond procedural fairness, the relevant case?
Well, I can take you quickly to other cases. The difficulty is that sort of let me put it this way, concise focus on the language isn't the hallmark particularly of the cases. I mean, it may be worth, can you just give me one moment just to look at the cases I was intending to take you to? I'm not sure, can I just take you to Boyce? Sorry, forgive me, to Ferguson. I may need to go back to Boyce, although I should say I've dealt with Boyce extensively in the written submissions, and my lords will have that point about the narrow and broad meaning. Can we just turn to Ferguson, which I think you'll find at 2355. Now, it may be that in a proper analysis, this is a fairness complaint. So let's check. Yeah, got it. This was a case, I'm not sure, no, none of my lords sat on it. It's a case where there was basically what happened was that the government enacted legislation which had the effect of meaning that offences which were more than 10 years old could never be prosecuted. They realized that wasn't a very good idea because that meant the number of prosecutions and important prosecutions could no longer be pursued. So they amended the legislation or restored the position by statute. They then, that was then criticized, the amendment, as being retrospective in its effect, and Lord Sumption had little time for it. Can I just make one additional point? I forgot to make this because of the question for my Lord and Lord Hamlin. To the relevance or importance in our submission of Thomas and Baptiste to our case, leaving aside the debate that we've engaged in a moment ago, is that that was an act of the executive in Thomas and Baptiste. And that's unusual because normally the cases in this field are complaints that Parliament has transgressed into the judicial arena, and that's the Ferguson case. So could I invite you just to read Ferguson, the head note?
Forgive me, Mr. Clayton. For what proposition do you rely on Ferguson?
Well, I was asked by my Lord Hamlin whether there was a case which wasn't simply a complaint of due process. The best example I can give you today is the Ferguson case, and I was just going to invite you to read the head note.
Thank you. This was a case, Mr. Clayton, where the legislation affected the law which was applicable in current proceedings. So I can see why that was an interference with due process, with procedural fairness.
Not sure, sorry. No,
it's a bit of a leap from that to the present case, isn't it?
At the end of the day, in our submission, much will depend on how my lords view the criticism, but we would respectfully submit that a failure to be able to rely on legal obligations under section 54 and 6 had a procedural consequence, because the appellants were entitled to expect and believe that the statutory regime that Parliament had declared, sorry, that the executive had declared, would be operative, and it simply wasn't. Now, in our submission, and I'm not seeking to, in any sense, go over old ground, the case here is a striking example in our submission of a problem which is fortunately rare, as we understand it. I can't find any cases which are on all fours, where the executive have chosen to deny the appellants the statutory rights which Parliament had enacted and which they had pronounced upon. Yes, Lord Burrows.
Yes. Can I just be clear as to your precise submission in relation to 4A? Are you saying, yes, it means procedural fairness, and in our facts, there is an element of procedural unfairness? Or are you saying we have to interpret 4A beyond procedural unfairness? I'm not quite sure at the moment which of the two you're putting forward.
My Lord, I'm making, it's my fault, because I'm actually making two alternative submissions. That our primary submission, which my Lord Leggett has debated with me, and I entirely accept the American case law on this is both complicated and maybe germane. Certainly it is for some of it. But the alternative is that the alternative submission is, if we're in the territory of procedural fairness, then our submission to my Lords is that there is a procedural element which we're entitled to complain about for the reasons I just indicated, which is that we have law that's in force, which has no legal impact on the court decisions.
So you are saying that that 4A does extend beyond procedural fairness as an alternative?
No, sorry. Can I reflect on that? I mean, we're going to have a short break because.
Why don't we take a short break now, and you can reflect on that. We'll take 5 minutes.
Thank you very much.
Then we'll return to it. Thank you very much, Mr. Clayton. Mr. Clayton.
My Lords, can I crystallize it a better form? I don't resolve from the submission that I made, which was debated with Lord Leggett, that the rule of law is an organising feature in this case. But what I do want to make is an additional submission about the procedural elements to it. The procedural elements to it in our submission are at least these. First, executive inaction resulted in the appellants not being afforded the legislative provisions which were in force. And second, and this is in our submission is an important constitutional element, executive inaction prevented the courts from giving effect to legislation which was in force. And it effectively rendered access to the court, well, certainly inhibited it, if not made it nugatory.
The first way in which you put that, Mr. Clayton, that executive inaction meant that the appellants were not afforded the benefit of the measures in force, rather strikes me as coming within 4B rather than within 4A. And for my part, that's a matter on which I would be glad to hear you.
Well, thank you. I was intending to move directly now to 4B, if I may, but I just wanted, before doing so, to try and clarify the confusions that I've created.
Yes, I don't want to. I'm not hurrying you along. I understand. Like to hear that. Thank you.
I think, with respect, my Lords have the submissions which is necessary for me to make on 4A, so I can move straight to 4B. And I think for those purposes, I'm going to confine myself to what was said by the board in the Maharaj case, which is at 2441. This was a judgment of Lord Kerr. If you could turn to 2443, please. I'm going to take a bit of time on this case because in our submission, it's the most important case on this particular area. Beginning at paragraph 1, just to see the factual claim, the appellant brought the appeal not to award him damages, for the Court of Appeal not to award him damages, and a claim made by him against the Prime Minister and Cabinet because the Cabinet decided he could not be reappointed as a member of the Industrial Court. Just to get the facts straight, turning the page, paragraph 8, he had been a member of the Industrial Court from 94 until 99. This was a complaint made against him. Mr. Ashon claimed that his observation of the appellant was that Mr. Maharaj could not write, read, or speak properly and was therefore not suited to be the Industrial Court. That was the complaint made against Mr. Maharaj. 10, next page, second sentence of 10. He said he had not been aware of any adverse comment. This is he, Mr. Maharaj, in a reply in affidavit. He claimed he had no contact with Mr. Ashong, and he suggests that he wasn't in a position to assess it. And then if you could turn the page to 2447, the approach of the Court of Appeals really summarized that the compensation was, the decision not to award the appellant compensation was premised on the notion it was incumbent on him to show he would be reappointed if the Cabinet had considered his application for reappointment. And then there's some discussion about the equal protection claim that the claimant, appellant wants to advance. And if I could ask you to turn to 2449. Paragraph 24, paragraph 25, forgive me. The board is, this is picking it up from the second line. The board is satisfied there's no reason to allow the appellant to advance the constitutional argument in a series of cases where the protection of the law provision in constitutions in various Caribbean countries were considered. An expansive approach to its potential application has been taken, and then reference is made to the Joseph and Boyce case. So broad and pervasive, it would be well nigh impossible to encapsulate a section of the Constitution. That's quoted by the Court of Appeal. I mean, all these two cases, the Boyce case and the Mayor Leaders case, are both decisions of the Caribbean Court of Justice. Going to the Mayor Leaders case, if I could just ask you to read it, and then I want to draw attention to certain bits of it. The passage cited from the CCJ and in paragraph 26, please. And then actually, you should read 27 and before I make my submissions about 26, please. Paragraph 27.
Yes.
Thank you, my lords. Just a few things I want to get out of the Mayor Leader's case. First is that the scope of this right is very broad. Secondly, it says in terms, the concept goes beyond the question of access and includes arbitrary exercise of power. That's the complaint we have in this case. And the next sentence, again, is important. The right to the protection of law may, in appropriate cases, require the relevant organ of the state to take positive action to ensure and secure enjoyment of basic constitutional rights. In appropriate cases, the failure of the state may result in a breach of the right to protection of law. That's in our submission in this case, or at least comes within the ambit of the scope. And then picking it up at the very bottom of the page, where the citizens' rights have been otherwise been frustrated because of governmental omission. So we say we come within the scope of the right. It's very broad, so perhaps that's unsurprising. And the next passages I want to draw attention to, which I can do at speed, I think, is that in the next few paragraphs, the board refers to fairness complaints coming within the scope of the right. That's paragraph 29 is a fairness complaint. Paragraph 30 is a fairness complaint. Paragraph 31 is also a fairness complaint. And then could I ask you to turn to 2453? If you have that.
Paragraph
37, access to the court is an important aspect of the constitutional protection, but for the protection to be effective, access to justice must be prompt and efficacious. In this case, the appellant was deprived of any form of remedy for many years. I want to make 2 points, which and come back to the same point in a second. For the reasons indicated by Lord Bingham in Ray's, constitutional rights are to be interpreted generously and purposively, and in order for access to the court to be of value, it has to be efficacious or effective. And my lords, Lord Carr says that on behalf of the board expressly at 37. And if I could ask you to turn the page, please. Well, perhaps you're not turning pages. 2454, please.
paragraph
43.
Thank you.
The submission is made effectively about the relevance of judicial review. That's at 42. 43, the board does not agree. The availability of judicial review is a factor to be considered in considering whether a constitutional claim that an individual has been denied the protection of law should be entertained. It is not determinative of that issue. I rely on that in the context of this case, where effectively the same submission is made by my friend. In the present case, it was open to the appellant to challenge the decision not to report by way of judicial review, but as was the case on the second ground, this was not an effective or timious remedy. Now, I'm not making a complaint about timiousness, if I pronounced it correctly, but in our respectful submission, and this is not a criticism of the courts, the courts were faced with a very difficult position, and the reality is the appellants did not get any effective relief. They were simply, what actually the relief that they were granted was by the Court of Appeal. Let me just find this in a moment in my note. In fact, what they were finding, I think it's paragraph 100 in the Court of Appeal judgment. Can you just, sorry, just give me, yes, it's the Court of Appeal. I'm so sorry. Just bear with me. So what I'm seeking to demonstrate, forgive me, but it is there, is the actual relief granted by the Court of Appeal was that the Chief Justice's were declarations made in respect of the Chief Magistrate alone, that they were simply confined to that, and that with respect doesn't, in our respectful submission, deal with the seriousness of the breach, and nor does it deal with the fact that it encompasses more than just the Chief Magistrate, unhappy as her position was. In our submission, the relief certainly didn't cover anything to do with the steps taken by the failure of the state by omission. Now, if I could next,
Mr. Clayton,
yes,
does that mean that we should disregard completely the mandatory order of the High Court in November 2015 and the positive impact of that order vis-a-vis Sasha, who was transferred within 3 weeks to a statutory community residence?
our understanding, my lord, was that she was moved on the 7th of December.
Correct. That was 26 days after the High Court order.
Yes.
Well, it was that's true, but it was 5 months after. I accept my lord's point, but it was 5 months after the legislation was brought into effect, and in our submission, it's a matter for my lords essentially. Our submission, my lords, is this is the prohibition from putting a child, albeit an older child, in adult prison and associating with adults in prison is an important form of protection for them. Now, I can't improve on the facts, but in our submission, whilst eventually it takes, as my lord says, the courts did respond in the time frame that my lord said, in our submission, that doesn't really cover the fact that it was for a 5-month period of time. It does take time for children. I mean, I'm sure I don't need to say that it takes time in Trinidad perhaps to get proceedings on a footing. My lords will probably appreciate that this case generated a great deal of time and energy, and the clients themselves are not particularly well placed to incur those sorts of fees. So my lords will know that that's the reality. And I suppose what I would say more than anything else is that in the end, as it is with any access to court debate, the real question is it effective? And it did take some period of time.
The time lapse in Sasha's case was 3 months from the grant of leave to apply for judicial review. Can you confirm that Brian did not secure a comparable mandatory order, because there's no mention of it anywhere in the papers?
That is correct, my lord, yes. And I'm reminded that St. Michael's Home was not a licensed community residence either.
But is there some explanation for that?
Paragraph 4 of Cochrane's judgment, he says that the circumstances are unknown because it was after he was over.
It's dealt with in paragraph 4 of Mr. Justice Cochrane's decision.
Fine.
Apparently, that it's all a bit unknown.
Page 444.
No, what's the bundle reference?
Page
664. I understand, my lord.
Thank you.
Page 4. Page 433.
Sorry, that can't be right. Yeah, can I just, we've given you, my lord, the paragraph. I'm sorry, it's not working very well for us here at the moment. Can I, I obviously accept the points my lord make about the time frame, but in our submission, it's important to look at the facts of this case overall. And I would draw attention to the following features of this case, which in our submission make the executive's omission, if I may call it that, to give effect to the to section 54 and 60 is arbitrary. And we say it's arbitrary for at least these reasons. First, the witness statement of the Permanent Secretary Budram does not explain why the executive made these provisions operational before building any community residences. It fails to do that, and that's arbitrary. It's also arbitrary because the purpose of section 54 and 60, was to introduce a regime which was designed to address the heightened vulnerability of children in custody. The third difficulty, subject to the point made by Sir Bernard McCloskey, is that taking proceedings took some time to secure any benefit. And fourthly, and importantly, in our submission, the executive omissions both disabled the magistrates and had a powerful impact on the interim applications and the orders that were open for the courts to make in resolving a friction which arose entirely as a consequence of the failure to make the act, or the failure to make those provisions operational in May. Turning to a slightly different point, my friends seek to rely on the Mayan leaders case by saying, this is in paragraph 37 of their case, page 1910, as I understand it, that the Belizean land law did not, so the Belizean land law did not protect the rights of the Mayan people. So they were denied access to protect rights. And he says, or submits, that that explains the approach taken by the Caribbean Court of Justice in that case. But with respect, we submit that here in substance, access to the court was not effective or efficacious to protect Brian and Sasha's rights for the reasons I've enumerated a moment ago. So in our respectful submission, that ineffective access to the court, whether for the reasons that occurred in Belize or the reasons in our case, are identical. And then the next points I can take at speed is in our submission, the failure of the Court of Appeal to deal with particular submissions did amount to an error in law at various stages. For example, at page 118, paragraph 19, there was a submission that the appellants were not imputing ill will to the magistrate or the state. At 1227, paragraph 95, the last sentence says no questions were raised as to the magistrate's bona fides. That's at 1235, paragraph 110. And again, in relation, that was in relation to section 4A. In relation to section 4B, it was again said the bona fides of the chief magistrates of the state were not called into question. And that's at page 1241, paragraph 124. With great respect, the Court of Appeal should have held that the bona fides of the state were entirely irrelevant. And we would draw attention, and I don't think I need to take you to it, to a decision of the Trinidad Court of Appeal, which is called Daniel and the Attorney General, which is at 2732. Paragraph 20 says in terms that that bona fides is irrelevant. That's paragraph 20 is at 2740. And then in relation to equal treatment, the same point is made by Lady Hale in Webster. It's a more extended discussion because I think it's more stated more frequently, but that's to be found at 2644, and the discussion by Lady Hale is at paragraphs 22 to 25, page 2645. So in our submission, it's of no relevance whatsoever to say in a constitutional case that the state is, or whoever it is not acting in bad faith. That is the law in Trinidad. And frankly, in our submission, the Court of Appeal should have attached weight to that. And there was really very little explanation for the position that the state was in. Now, there's, I think, one additional point, if you could just bear with me. Yeah.
So to a community residence, including Sasha, she went to St. Jude's.
My lord, I'm also reminded that despite the moves, neither were ever moved to community residences, and that Sasha went to St. Jude's, which is again not a community residence. I think I need to come back to that. I'm told. I'm sorry. Can I do apologize, but I'm going to have to come back to that. Sorry. Can I just look at one additional matter, if I may? And I think my lords will have read this as well, but the one additional point I want to make is actually set out in paragraph 71 of our case, which is at page 1889, where we make various submissions about why the breaches of sections 54 and 60 are of particular significance to children. And in our submission, that's of some importance. My lords, subject to conferring, if I may briefly, with my colleagues, I think those are all the submissions I can usefully make at this stage. I just wonder if I could have a moment.
Yes, of course.
Thank you. Is there anything else?
No.
So I think my lords, subject to one factual matter. Oh, I'm so sorry.
Well, this may be the matter you're going to clarify, but was St. Jude's School for Girls a community residence?
It wasn't, no. But I think there is a factual inquiry I want to make if I could deal with it after the short adjournment, because I have to go to Trinidad to get complete clarification of the position.
Yes.
Maybe, Mr. Clayton, you would reflect on what we have read in the Statement of Facts and Issues, that on the 7th of December 2015, Sasha was transferred to a community residence. Unnamed.
It's also in the chronology.
Yes, I think, my lord, it's probably not helpful at this stage, and we're getting information from Trinidad, but I think the position is an order was made. The problem was whether it was implemented, I think. I just need to get some clearer instructions, and I haven't been in a position to take them. Subject to that, my lord, and I do apologise for being unable to deal with Lord Leggett's question, I think I've covered all the ground I can usefully cover, unless there are any particular matters which my lord.
Okay.
Thank you
Think there are
very
any further
much.
questions? Thank you, Mr. Clayton. We're grateful.
Thank you.
Mr. Stevens.
Yes, my lord, I'm going to start with due process and follow the same route that Mr. Clayton has. Can I start by taking you to some local authority and other relevant authority as to the meaning and scope of due process? Could I ask you to look first of all at the case of LaSalle and the Attorney General, which is at 2651 of the electronic bundle. Now the case, the facts don't matter very much, but it concerned the composition of a military tribunal. If I could ask you to turn to page 2663 in the judgment of Justice of Appeal Phillips, starting just above letter D, it has been stated that the origin of the due process clause of the Constitution is the famous 39th clause of Magna Carta, with regard to which Professor Holdsworth states in his History of English Law, it has, I think, a very considerable constitutional significance because it lays down the principle that liberty and property are not to be interfered with without due process of law. Speaking of this clause and those immediately preceding and following, the learned author says these clauses do embody a protest against arbitrary punishment and against arbitrary infringements of personal liberty and rights of property. They do assert a right to a free trial, to a pure and unbought measure of justice. They are an attempt, in the language of the 13th century, to realize these ideals, just as the demand for the laws of Edward the Confessor was an attempt, in the language of the 12th century, to realize the same ideals. The account which I have just given of those, of its clauses which place limitations upon arbitrary government, will show us that in the Charter we get the first attempt to explain in exact terms some of the leading ideas of constitutional government. In my opinion, these words of Professor Holdsworth serve to elucidate the meaning and content of the expression due process of law as it is used in section 1A of the Constitution. Some of them can bear repetition. The concept of due process of law is the antithesis of arbitrary infringement of the individual's right to personal liberty. It asserts his right to a free and pure, unbought measure of justice. While it is not desirable, and indeed may not be possible to formulate an exhaustive definition of the expression, it seems to me that as applied to the criminal law, in which category I include offences against military law, it connotes adherence, inter alia, to the following fundamental principles. 1, reasonableness and certainty in the definition of criminal offences. 2, trial by an independent and impartial tribunal. 3, observance of the rules of natural justice. It is worthy of notice that the observance of 2 of these safeguards is expressly provided for by section 2, paragraphs E and F of the Constitution. Now, my lord, section 2 is now section 5 in the 1976 Constitution, and it is otherwise in identical terms, of which have been quoted above. As to the requirement of certainty in the definition of criminal offence, it seems to me that it's impliedly provided by paragraph C, which recognises inter alia, and I'm not sure I need to set out 1 and 4. Then, as I said in Bazzi and the Attorney General, the object of section 2 is to secure the protection of all the rights and freedoms which are enshrined in section 1, so that's section 2 of our Constitution, since the administration of justice is the instrument by means of which the citizen seeks to enforce or prevent encroachment on his rights. The scheme of section 2, for us section 5, is to prohibit the enactment of legislation which may have the effect either of A, abrogating, abridging or infringing any of those rights, or B, depriving citizens of the benefit of any of several procedural safeguards established for the purpose of ensuring the due administration of justice. The observance of these safeguards is, in my view, an essential requirement for the preservation of all the substantive rights and freedoms guaranteed by section 1 of the Constitution. In this context, the significance of the fact that no allegation has been made by the appellant as to the actual infringement of any of the procedural safeguards guaranteed by Section 2 of the Constitution cannot be overestimated. I'll be making a similar point in relation to the present case, my lords. Can I then just ask you also to look at the judgment of Justice of Appeal Fraser, 2683, between letters C and G. The references which I've cited, both from the United States and from Canada, serve to demonstrate that in both countries, due process is seen to be construed as a restraint upon action or a limitation on law which affects personal liberties to a degree of unreasonableness or arbitrariness, which is coloured by discrimination or otherwise. The introduction of the due process clause in the Constitution seems to me to have been similarly inspired, although the method has been different and at the same time more clearly explicit in the legislative intention. Section 1A of the Constitution declares as fasciculus of individual rights to have existed and assures their continuity without deprivation except by due process of law. But the section does not itself provide the means whereby individual rights might be protected against their abrogation, abridgment, or infringement. Such protection is to be found in Section 2 of the Constitution. And because this is so, I think that Sections 1A and 2 are complementary and together provide the content and values which underscore the legal civil liberties of the individual as distinct from his political civil liberties, his economic civil liberties, or his egalitarian civil liberties. The individual legal civil liberties concern the justice of the legal order and speedy trial, and include freedom from arbitrary arrest or arbitrary search and seizure of person, premises, and papers, protection of impartial adjudication involving notice and fair hearing, an independent tribunal, and the right to counsel, the privilege against compulsory self-incrimination, the protection from cruel and unusual treatment or punishment, the right to be informed promptly of the reasons for his arrest or detention, the presumption of innocence, the right of the assistance of an interpreter, and to all the other facilities and rights protected from legislative interference by Section 2 of the Constitution. Now, my lords, a number of things in my respectful submission are clear from LaSalle. First, due process is a safeguard against arbitrary infringement of the right to personal liberty. Secondly, in the context of the criminal law, due process requires adherence to certain fundamental principles, including those enumerated by Justice of Appeal Phillips at little 1 to little 3 at 2633. Thirdly, that those principles and other things are reflected in that case, Section 2, in our case, Section 5 of the 1976 Constitution, which prohibit legislation which may have the effect of abrogating the Section 1, or for our purposes, Section 4 rights, or depriving a person of certain specific safeguards. And fourthly, that the two sections, 1 now 4 and 2 now 5, are complementary. And the latter section in each case provides the specific means by which the rights provided for in the former are protected. My lords, the interrelationship between the two sections is important in understanding what is meant by due process, what it includes. The provisions at A to H of Section 5, insofar as they concern variously the deprivation of liberty, the trial of a person charged with a criminal offence, or the rights of a person engaged in criminal or civil legal process, provide, in my respectful submission, the clearest, although I accept not necessarily exhaustive, indication of the essence and content of due process. And this interconnection between the two sections and the fact, as I put it, that the latter informs the content of the former, to which both Justices of Appeal Phillips and Fraser drew attention in LaSalle, was also recognised subsequently by Lord Diplock in the case of Thornhill. And you have that at 2622. I hope I'll be forgiven for not taking you to the facts of the case. The passage that I would ask you to look at is at 2631. It's very short and it starts at letter F. Of course, Lord Diplock here was speaking of the 1962 Constitution, and so we find reference to Section 2. But Section 2 also goes on to give as particular examples of treatment of an individual by the executive or the judiciary, which would have the effect of infringing those rights, the various kinds of conduct described in paragraphs A to H of that section. These paragraphs spell out in greater detail, though not necessarily exhaustively, what is included in the expression due process of law, to which the appellant was entitled under paragraph A of section 1 as a condition of his continued detention, and the protection of the law to which he was entitled under paragraph B. So Lord Diplock, endorsing effectively with what was said by the two justices of appeal in LaSalle, namely that one has to look at section 5 as an aid to interpreting what is embodied in due process, and those subsections at A to H, in Lord Diplock's words, albeit not exhaustively, spell out what is included. Now, just to add this, in another case called Attorney General and MacLeod, a few years later, I should acknowledge that Lord Diplock declined an invitation to supply a comprehensive definition of, he was asked to define the protection of the law, referred to in Thornhill, and observed that the problem of defining what is included in each of the fundamental human rights and freedoms in sections 4 and 5, so due process as well as protection of the law, was best dealt with on a case-by-case basis. You've got that at 2337, and the particular passage appears at letter C, where I'll be returning to this in due course, but at letter C, their lordships have been invited by the appellants to supply a comprehensive definition of what is meant by the expression the protection of the law in section 4B. This is an invitation which their lordships consider they must decline. There's then reference to Thornhill and what was said in Thornhill, which I've just taken you to. And then at H, in that passage, their lordships took the precaution of incorporating the words in parenthesis, though not necessarily exhaustively. An appeal which is undefended does not provide an appropriate occasion to jettison the precaution and to embark upon an attempt to provide a more exhaustive definition of what is meant by the protection of the law. The problem of defining what is included in each of the fundamental human rights and freedoms in the lettered paragraphs of section 4 and 5.1, so that obviously includes due process as well, is best dealt with on a case-by-case basis. Now, my lords, it's fair to say that so far as due process goes, it's still not been, and it may never be, in my respectful submission, exhaustively defined. So as recently as 2016, as you were shown in case of Ferguson, which is at 2355, at page 2364, Lord Sumption, giving the judgment of the board, noted at paragraph 18 on 2364 that what is comprised in due process has never been exhaustively defined, adding, however, that it has always been taken to include the resolution of justiciable issues by courts of law without interference by the executive or legislature. Now, my lords, what is clear from the various authorities, in my respectful submission, is that due process concerns the legal process and procedural fairness. And it extends that far, certainly, but does not extend as far as Mr. Clayton would have it go, in whichever of his formulations he advances. Moreover, it's clear in my submission that the object of all the specific provisions of Section 5.2, Section 2 in the 1962 Constitution, apart from B, which is concerned with cruel and unusual treatment or punishment, is to guarantee procedural fairness. And support for the proposition that due process, as indeed the word process itself implies, my lords, is concerned essentially with procedural safeguards, is to be found in a further judgment of Lord Diplock, namely Maharaj. Now, that's not the Maharaj that you were shown just now, Sam Maharaj, but it's at 2415. And the relevant, this concerned an attorney who later became Attorney General of Trinidad and Tobago, who was committed for contempt, but beyond that, I don't think the facts matter. If you could look at page 2429, please, starting at letter D. Lord Diplock said this: in the first place, no human right or fundamental freedom recognised by Chapter 1 of the Constitution is contravened by a judgment or order that is wrong and liable to be set aside on appeal for an error of fact or substantive law, even where the error has resulted in a person serving a sentence of imprisonment. The remedy for errors of these kinds is to appeal to a higher court. Where there is no higher court to appeal to, then none can say that there was error. The fundamental human right is not to a legal system that is infallible, but to one that is fair. It is only errors in procedure that are capable of constituting infringements of the rights protected by Section 1A, for which read our equivalent section. And no mere irregularity in procedure is enough, even though it goes to jurisdiction. The error must amount to a failure to observe one of the fundamental rules of natural justice. And that is exactly what, in passing, Lord Millet was talking about in the case of Thomas and Baptiste, and supports, in my respectful...
Sorry, Mr. Stevens, I'm very sorry to interrupt, but could you just give me the page reference for the Diplock again? I'm just trying to find it. I apologise.
Of course, my lord. So it's at letter D, and I read from letter D to 2 lines above letter F. It's not a numbered paragraph, my lord. I'm sorry.
Oh, sorry, page, electronic page number, please.
2429.
2429. Thank you very much.
And my lords, what one gets from that and from the other authorities is very much what, in my respectful submission, Lord Millet was talking about, as with respect, explained better than I can by Lord Leggett in the exchange that the court had with Mr. Clayton in relation to the relevance of the rule of law. What is in issue is procedural safeguards as fundamental, universal in that sense, and for that reason, aspects or components of the rule of law, fairness, and that is what due process is concerned with. Maharaj is a case that the respondent relied upon in another case, which I thought Mr. Clayton was going to take you to, but he certainly refers to it in his printed case, and that's the case of Naidiki. That's at 2459. And at page 2476, at the top, paragraph 53, in support of the first, Mr. Guthrie refers to the well-established principle conveniently summarized in the board's recent judgment in independent publishing as follows: in deciding whether someone's Section 4A right not to be deprived of their liberty except by due process of law has been violated. It is the legal system as a whole which must be looked at, not merely one part of it. The fundamental human right, as Lord Diplock said in Maharaj, is to a legal system that is fair. And then at paragraph 54, and Mr. Guthrie, acting for the state, submitted that the legal system as a whole was fair to Dr. Naidiki. It was an immigration case, and it related to whether he was permitted to stay. In paragraph 55, the fact that the arresting officers and the chief immigration officer who gave the instructions for Dr. Naiki's address honestly believed that he was a person referred to in section 9(4) of the Act cannot avail them. The officer's reasonable suspicion under section 15 had to relate to the existence of facts that would in law have justified Dr. Naidiki's arrest, not to the state of the law itself. A mistake about the law giving the power of arrest cannot of itself found the power of arrest, nor can the court's habeas corpus jurisdiction of itself operate to defeat Dr. Naidiki's claim to have been deprived of his liberty otherwise than by due process of law. Had Dr. Naidiki been arrested and detained pursuant to a court order, as was Mr. Ali, that would have been another thing. The reference to the legal system as a whole is not apt to encompass loss of liberty through executive action, such as was taken in the present case. Now, my lords, I only mention that case. I appreciate it's only been cited in Mr. Clayton's written argument to make the point that there is a critical difference when that case is compared to the present case. In that case, there was no power to arrest or detain Dr. Naidiki, and there was no court order. In the present case, there is no challenge to the appellant's arrest, self-evidently, and their detention was mandated by the Bail Act, the provisions of which, because they were arrested on suspicion of murder, were mandatory. And there's been no challenge whatsoever to the Bail Act. So unlike in Naidiki, there can be no question at all, if it is suggested, of a loss of liberty through unjustified executive action. Now, my lords, having digressed, can I return to the specific procedural safeguards in section 5.2? I read a sentence from LaSalle in which it was observed that there was no complaint made in that case of breach of any of those requirements. Well, exactly the same can be said of this case. There is no allegation of a breach of any of A to H. And it's difficult with respect if one understands those provisions as informing the content of due process and one proceeds on the basis that essentially it is about procedural safeguards to comprehend how the appellant's rights under section 5A were breached. Yes, my lord. My lord is muted, I think.
Can you hear me now?
I can.
Yeah, sorry, I was.
That's all right.
Might one put it this way? Maybe this is how Mr. Clayton put it. I'm not sure, but could you say that part of a fair process, due process, is that the court will enforce the law or apply the law, and a deliberate court decision to not to follow the law which says you shall not order a child to be detained in an adult prison, but exactly to make such an order, is not due process if a court deliberately and knowingly makes an order that is contrary to a significant provision that Parliament has enacted. Now, maybe the court didn't have a choice, we know that, but that may not make it any less a fundamentally unfair thing that the law is not applied and is deliberately disapplied.
My lord, that with respect doesn't go to the fairness of the proceedings, and the court did not have any choice, and indeed that was the dilemma which was considered by the board in the appeal brought by Sasha against the order made for interim relief. And the board, the judgment in that case was given by Lady Hale, and certainly it's in your bundle. The court recognised that there was no choice whatsoever because of the mandatory requirement of the Bail Act, against which there was no challenge, constitutional or otherwise. And in
That was
those,
a choice, in effect, really, because either the choice was between breaking law A or breaking law B.
well, my lord, where, I mean, yes and no, my lord. The position was that the court had to make a choice, and the choice the court made was that the primacy should be given to the Bail Act, because there was no question but that they should be detained. And the objection now is, of course, that they were detained somewhere that they should not have been, not that they should not have been detained. Now, that, in my respectful submission, does not affect the fairness of the proceedings, which concerned the question whether two children charged with murder should be detained as required by the Bail Act. And the magistrate acted appropriately in detaining them. There was nothing unfair in doing what the law required. As to whether or not the place they were detained was appropriate, that's a slightly different question that may have engaged, and certainly did at first instance and in the Court of Appeal, questions as to whether or not it was suitable or in fact infringed the Section 5(2)(b) right, but not a question that engaged the question of procedural fairness. The quality of the place of detention was what was in issue, not the fairness of the process by which they were ordered to be detained. My lord, yes.
Yes, I'm just wondering if I could just press that a bit further. Can a process be regarded as fair if it is putting the magistrate in an impossible position in relation to laws that cannot both be applied at the same time? I mean, one might say that process is something of a charade because it produces an impossible outcome for the magistrate.
Well, my lord, an impossible outcome in one sense, yes. And what the magistrate had to do was to remand them in circumstances where she had no choice, and remand them to the places that she thought were most appropriate in the circumstances. Now, there was subsequently, obviously, a challenge to that, and the lawfulness of her decision was found. It was found to have been unlawful, and there's absolutely no challenge to that, and I entirely accept that. But that doesn't mean that the procedure that she followed was in any way unlawful. The children had the opportunity to be heard and were heard, and she thereafter acted in accordance with the mandate of the Bail Act. Now, because of the absence of appropriate places of detention, further litigation followed. And in that respect, I'll be submitting in due course that amounted to the provision of the protection of the law. But my lord, the actual legal process, the hearing before the court, was fair, and none of the specific requirements of Section 5(2) or the requirements of procedural fairness, as that is understood in the public law sense, were infringed. The result may have been, in one sense, unfair to the children, but that's not procedural unfairness. That's injustice in a different way, because they were put in a place of detention where they ought not to have been, because the place they ought to have been in was not available. But that's not procedural fairness with respect. My lord, I just made the point, I think, that there was no complaint, and there is no complaint in the present case of breach of any of those specific procedural requirements, nor is there any other complaint of a failure to comply with natural justice or any other sort of procedural requirement that one can conceive of. And significantly, there is no longer any complaint of section 5.2c. Rather, the complaint in substance is of, as I've just been saying, non-compliance with a statutory provision moreover contained in an ordinary law, not, and it's an important but obvious point, not a constitutional provision, namely the Children Act. And that did, as I've accepted, require that they be remanded in a community residence. But the failure to remand them with a in a community residence, unless one can point to a procedural failure of the type that I have suggested engages section 4A, does not mean that the complaint can be brought within section 4A. Now, my lord, you've been taken to Thomas and Baptiste, and I don't think I'll take you back to it because Mr. Clayton read all of the passage at 2603 that is relevant. But in that case, Lord Millett, rather like Justice of Appeal LaSalle, and indeed Lord Millett acknowledged the debt that the board owed to Justice of Appeal Phillips in LaSalle in that case. He traced the clause back to Magna Carta, just as Justice of Appeal Phillips had. And he recognized that the clause excluded both legislative and executive interference with the judicial process. Now, pausing there, there's nothing of that sort in this case. But he explained that it went further than that. And he said that it invoked the concept of the rule of law itself and the universally accepted standards of justice observed by civilized nations which observe the rule of law, and therefore gives constitutional protection to the concept of procedural fairness. Now, I appreciate I may simply be repeating myself, but the focus in all of these authorities, and even in Thomas and Baptiste, which I think Mr. Clayton sees as the high point of his case because of the reference to the rule of law, the focus is on procedural fairness, not on an outcome which might be unfair in the sense my Lord Burrows has suggested for the children. And they're two distinct things. The court might take the view that it was unfair, and I accept that they were unlawful orders that the magistrate made, and in that sense, they shouldn't have been detained where they were, and in that sense, unfair. But that's not, I reiterate, and I promise not to do it again, that's not procedural fairness. That's not a breakdown in the requirements of procedural fairness or natural justice or anything of that sort. My lord, I see the time, and I'm content either to continue or to stop, but it's a convenient moment. It's
time to stop, Mr. Stevens. We'll take a break now and we'll resume at 2 o'clock, please.
Thank you
very much.